All right, so let's talk about mandamus lawsuits. And mandamus is a word that comes from the Latin that means we order. And what we mean by that is that a lawsuit, a mandamus lawsuit, which is also called a writ of mandamus, is a legal action that asks a federal court to compel a government agency to perform a specific duty. So it might sound a little confusing, but what this means is that in the context of an asylum application, you or your lawyer could file a mandamus with the Department of Justice, which then will force USCIS to either schedule an interview for you or make a decision on an asylum application that is pending and for which you've been waiting for a while. It's important to understand that the mandamus lawsuit acts by putting pressure on the Department of Justice, which in turn forces USCIS or another federal government agency to do their job. And in that sense, it's very different from any other methods that we have to talk to USCIS directly, such as asking for expedited interviews or to be put on short notice lists or things like that, which I'm sure some of you have done and which may lead to nothing. The reason why this works better than other methods is because the Department of Justice is involved. And so more recently, mandamus lawsuits have become more popular. Before 2021, they would represent about 1/3 of all immigration lawsuits, about 1,300 per year. But now in 2023, they're expected to be about 2/3 of all these lawsuits, or about 7,000 cases per year. So they have significantly increased. And we don't know how many of these increased numbers are all about interview scheduling. And we also don't know how the outcome of the lawsuits is decided, but we do know that their numbers have increased significantly. Martha, can we go to the next slide, please? So in order to file a mandamus lawsuit, there are a number of things that you must have done, or you would be in a situation to do so. It only applies to affirmative action, affirmative asylum. You would have to wait for your interview for more than 3 years. It's kind of a rule of thumb. Of course, it could be more, unfortunately, but it's probably not a good idea to try this really soon after you file. And also, you have taken some other steps to try to make your case advance and your interview schedule, and you have documented that such that you've been basically showing good faith and due diligence in trying to get your interview scheduled. Also, it's important that your case is fully prepared and ready to present, that you have all evidence that you might be expecting and so forth, because if it works, and we think it does, then you could be called for an interview relatively soon after your lawsuit has been filed. So you must be ready to be interviewed. Couple of notes that it's not because your interview has been scheduled that it will be approved. The decision on your actual asylum case is completely independent of the lawsuit itself, but also it's not going to have a negative impact on it. It's not because you ask the government to do something that they owe you, namely scheduling your interview, that it's going to reflect negatively on the decision on your case. Can we move up, Martha, please? So there are some advantages and disadvantages of doing this. I'm starting with the negatives. Let's say, for instance, you need more time to find an attorney or gather evidence on your case, or to find witness to write letters about you, or you need more time to get medical records or things like that. Or just you think that maybe your case is not that strong and you prefer to be able to stay and work in the US for as long as possible while your case is pending and there's no downside for you in waiting, then maybe this is not really something that you want to think about. On the other hand, if it's really difficult for you to wait and it's putting you under a lot of psychological pressure, the uncertainty of waiting, if you have left family back in your home country and you want to be reunited with them, if you have an emergency or a medical condition that requires attention, or in the case that your asylum case could become weaker over time, let's say, for instance, the country conditions are changing in your home country and it's becoming more disfavorable to you, or your witnesses are not around anymore for you to testify in a number of years, then you might want to consider this. You really have to think about it. Each case is very different, obviously. So the way it works, so that's a little bit technical here, but I think it's important to understand because some of the technicality is what makes it difficult to do on our own, and that's why a lawyer might be needed to do this. So first of all, you need to create a document. It's called a complaint. It's a legal document that basically explains your situation, how long you've been waiting, what you've been doing to advance your case, how much that has been weighing on you psychologically, for instance, and you're asking for a solution for it, which is called relief. And basically you're asking the court to force the government to do what they're supposed to do. So then this is the part where the complaint itself is going to be filed with the Department of Justice. And it depends on your location. Basically, it could be based on your address or your asylum office, but it's going to be filed with the Federal District Court of the Department of Justice. And at the same time, it will be served, which means also filed with the appropriate government officials at the DHS, USCIS, and your asylum office. So a lot of people are going to receive a copy of this lawsuit. And what this means is that because the Department of Justice, which is the primary recipient of your lawsuit, because they want to avoid litigation, they are going to try to put a lot of pressure on USCIS to schedule your interview. Because if they do so within a certain period of time, then your lawsuit basically goes away, which is what you want, basically. You want your interview to be scheduled, or you want to receive an answer on your asylum application after your interview. You don't want necessarily to go to court and have to litigate this. I hope this is clear, but we can go back to this if necessary. So the next question is, are you going to need an attorney to do this? That's the subject of the next slide. So it's technically it's possible to do a filing on your own, which is called pro se. And to do so, you are going to use publicly available resources that are mainly available on the district court website where you would file your lawsuit. But as you may have already understood, or maybe you know from your own research, it is really complicated and challenging, not only because there are some legal requirements, but also a lot of technical procedures, like where to send stuff and within which time frame and things like that. And for that reason, you can just miss one technical part and your file is not properly registered. So as of today, we only know of one person in Los Angeles. I mean, we know at RIF, there might be other people, one person at RIF that has filed a mandamus lawsuit pro se. And she has received an interview notice for next April. So that's all we know for now, unfortunately. So the good thing about that is that it would be very affordable. You only have to pay the $400 filing fee, and you could ask for a waiver, but you do have a lot of work to do on your own, and you don't know whether you are going to be successful, not from the viewpoint of the the mechanism, but just because if you miss a step, then you may have to refile or do more work. On the other hand, if you have an attorney, it could be a lot easier for you than very little work to do, but it could be pretty expensive. I'm sure some of you have already looked into this and they know about the fees, which can vary greatly. And the trick is that not every immigration lawyer is able to file a mandamus lawsuit. What they need to do is they need to be admitted in the federal district court where the lawsuit would be filed. And a lot of immigration attorneys are not registered to do that. So then they would have to find someone to do it for them. And so that involves another lawyer, or they might not be even interested to look into this, or they might just ask you to pay some exorbitant sum of money for them to do the work. So what we think here at RIF is that it's really important to see if, based on the prerequisites, this is really something that works for you. It doesn't work for everybody. It could not work financially, it could not work maybe psychologically, and based on your individual immigration case, maybe this is a good option, maybe it isn't. Then of course there's a financial issue because it's costly. So we here at RIF, we think it's really a good idea to try to get a free consultation with an attorney who is admitted in the federal district court where you would file. And that's slightly different based on where your asylum office is located or where you live, where your address is. And so one thing that has been tried by some of our colleagues at other organizations is to send a letter to your asylum office, basically threatening them with a pending mandamus lawsuit unless they schedule you for an interview. So the outcome of this is not really clear because, as I stated really earlier, the reason why the mandamus lawsuit works is that because the Department of Justice is involved and they have a responsibility to respond to the public within a certain period of time. USCIS does not. So because of that, they may just not really look at your letter and just completely ignore it. So we think that it's only worthwhile exploring if you are prepared to then actually follow up with a lawsuit. Yeah, and so, and basically, again, as I said earlier, the lawsuit can be very effective in advancing your interview date, but it does not guarantee approval of your case. That's a different conversation. So that's it. We've just outlined here a couple of resources. There are probably more available, but right now I think we can go to questions.